Parker Law Group in Sarasota, Florida, which is conveniently located off of I-75 at Fruitville Road. We have 4 attorneys at the practice, practicing in the areas of personal injury, family law, and estate planning. Asked what the difference is between a contested divorce and an uncontested divorce. An uncontested divorce is when both the husband and the wife agree on all of the issues that must be resolved during a dissolution of marriage action, including the division of all of their assets, all of their debts, as well as custody, visitation or contact schedule, child support, and any other issues that involve the children of the parties. If the husband and wife can agree on all of these issues, then an attorney can draft a marital settlement agreement, and that agreement is then presented to the judge at a brief 5-minute final hearing to finalize the divorce. Based on how much time is involved. So it can be anywhere from $3,000 to $4,000 upwards of $50,000 to $100,000 for attorneys' fees and court costs. It's a matter of agreeing on a contact schedule for the parents with the child. One parent may be classified as the primary residential custodian, where the child sleeps most of the time. However, both parents are encouraged by the courts and by our legislature in Florida to spend quality time with their children and to maintain those relationships. So if the parents can't agree to what that contact schedule will be, then that's usually what makes a dissolution of marriage with children an uncontested dissolution, because there's no argument that they should both have continued contact and they can agree on a schedule, which is flexible. If they agree during a particular week that they need to change the schedule for one reason or another, the agreement doesn't have to be adhered to if the parties can agree otherwise. The marital settlement agreement is a fallback for the parents in the event that they stop communicating well and need additional guidance on what the contact should be with the other parent. Several things. Number one, most couples don't understand that the child support in the state of Florida is determined by the legislature, and that it is calculated based on each individual person's income, as well as the cost of any daycare that the child or children may require, as well as the cost of their health insurance premiums. Now, the child support can be differentiated depending on the number of overnights that one parent may have, so that if the parents have a 50-50 split of the child's time, then the child support would be less, but it is not eliminated. And parents often don't understand that process, and that's one reason why it's important for them to retain an attorney who can use the required information and calculate what the child support is supposed to be. Because if they go to court, it's not something that is fought over. The judges simply take the information from their financial affidavits, plug it into a computer program, and the child support number is calculated, and it is what it is. And the party responsible for paying it must pay it to the other parent. The other reason that couples believe that a divorce is contested, or that they start to disagree over the equitable division of their assets and their debts. In the state of Florida, the legislature has decided that any time a husband and wife separate and divorce, that their assets and debts will be equitably distributed. And those are all assets that were acquired during the time of the marriage, as well as all debts that were incurred during the time of the marriage, irregardless of whose name those debts may be incurred in or whose name the assets may be titled to. In other words, if the husband purchases a piece of land and titles it in his name during the time of the marriage, that property does not necessarily belong to the husband. Same with the debts. If the wife incurs large credit card debts during the time of the marriage, those debts are considered marital debt and will be divided 50-50 in most cases, irregardless of the fact that the wife may have incurred those debts during numerous shopping sprees or other outings that she may have participated in.